Were these people at the scene of crime? The locus in quo. That is a question that will be answered by the evidence that will be presented before this court. The DPP under Article 157(11) is the gatekeeper at the criminal justice system. We cannot allow, as mandated by the Constitution, under Article 157(11), an abuse of the court process. And therefore, we are neutral, an independent office, and we have to facilitate justice and present the evidence that we have against each and every person that is before this court. The responsibility is not communal. Each person will bear personal responsibility for any act that is seen or proven to have been done. In line with that, Your Honor, and in addition to the fact that we have evolution of law and acts since 2012, whereby you do not need to be affiliated to any terrorist group for you to commit terrorist act. A case in point, Your Honor, are the lone wolves. The lone wolves radicalize themselves online and mobilize people to violence without a clear group affiliation or guidance. Do we have a lone wolf before this commission? That is an answer that we can only get after the court looks at the evidence that is before them. I cede a few minutes here to Mr. Kamau, then Mr. Kamau to Ms. Wangui. Thank you.
Your Honor, the question before court, good morning, Your Honor. Good morning. And everyone else in the court. Good morning. Your Honor, I know this is a very serious court that deals with terrorism and counter-terrorism issues and transnational organized crimes. I don't know why people are so tense. The question before court is not very hard, Your Honor. The question before court is whether the DPP, in exercising its decision to charge, did it within the law and the limits of the law. Your Honor, Section 2 and the provision that has been highlighted by counsel, it also has a counter provision, and the counter provision is that, first of all, that provision limited persons being prosecuted for terrorism if acts were done during protests and demonstrations. However, the provision continues to say, if these acts shall use violence against persons, if these acts shall endanger human life and the safety of the public, if they create great risk to the health and the safety of the public, and also result to damage of property, they shall squarely fall within the meaning of a terrorist act. Your Honor, the charge sheet before you on the particulars clearly demonstrate that there was damage to property, serious damage to property, as has been highlighted by counsel. Area. Your Honor, the Parliament that 7 to reign terror and to commit acts of terrorism. When there is a scenario of demonstration, and you're reporting on what is happening, of people taking advantage of protest and demonstration. We are trying to show the court that indeed these are terrorist acts because they were done this guideline was given to a prosecutor. That when a prosecutor it can be checked. And how can we check it? We can only check whether PVP exercised this right and this right is not
on out. Terrorism Act. Are clear and are proper. And have been made under our mandate. So that we are able to support this council. Therefore, Your Honor, we submit that the charge
Your Honor, with a bit of hindsight, and I'm quite sure, Your Honor, that no Kenyan will look at these young people and call them terrorists. Of the act. And, Your Honor, as a terrorist, is on conviction to imprisonment for a term not exceeding 30 years, Your Honor. And this is a person who is where it is already publicly pronounced that over 500
Constitution. Now, Your Honor, if we may look at a casual reading of the statement of facts, the persons before you cannot respond if a plea was to be taken. We have watched, as Kenyans, persons wearing the National Police uniform, vandalizing private property in the company of members of the public in Kenya. The tragedy of allowing such a charge to proceed is that even though it may be saved at the end, probably with a discontinuation or termination of the charges, prejudice will have already occurred on the persons before the court. The reading of Section 4 cannot be isolated from the definitive definition of the term terrorist act. And because we have time, limited as it is, Section 2, and I will read it, says, prejudices national security or public safety, and then proceeds to put a rider and says, and. So this charge, in the particulars, cannot be left in isolation by saying, committed a terrorist act. It has to go with the sub B, which states with an aim. Mental state, what we call mens rea, is very important because the persons before you must respond to either of the three and not all. If they had to respond to all, then in the particulars of the offense, it would have captured it that way. But, yes, that the persons before you, that the statement, the particulars of the offense cannot be read in isolation without the mental state, the mens rea, intended to do what? So that it says and, which is carried out with an aim, so it particularizes them in three. One is to intimidate or cause fear amongst members of the public. If I am too fast, Your Honor, you could ask me to slow down. Yes. Number two, intimidating or compelling the government or international organizations to do or refrain from any act. And lastly, destabilizing religious, political, constitutional, economic, or social institutions.
This is the mens rea.
Yes, yes. So that as they are responding, if they will, the court will find that they should respond. They need to respond to a charge which is holistic. It is inclusive of what they intended to do. Now, finally, what the statement of facts states, and if the court will be minded to also look at the other count 2 and count 3, they are extremely identical to count number 1, with the exclusion of the term committed a terrorist act. Now, if the court would be minded to entertain all 3 counts, what the persons before the court will be doing would be to suffer not even double jeopardy, there's something like that. A criminal law lecturer will have to revise his manual, will be triple jeopardy. Because what it says generally is that property was damaged allegedly by the persons before you. Of great importance, I sit down, and this has not been addressed. It cannot be possible to commit acts under Porter when Article 37 exists, and the court will take judicial notice that in the charge sheet fall squarely on a date that Article 37 was applicable. And that being the case, the drafters of Porter would have stopped Section 2B and not included the proviso that I will read it for the court as it retires, provided that an act which disrupts any services and is committed in the pursuance of a protest. In fact, Porter does not use the description of the. It foresees that such protest may not be peaceful. So that, as we have seen, allegedly there was property that was destroyed or damaged, and it continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a mortician has rights. For instance, those who work in mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying. Morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side. And I any person who was urged not talk much about it because we are being led by senior counsel and he's my friend. It was meant to be a joke, but everyone is serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now I'm like the VPP, I mean it. Count number 1, because we will come to discuss the other counts. As I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the BPP is itching to say that the Kikuyu court is not functioning. But there is another court nearby which can handle.
Referred to by Mr. Mwangi. Mr. Mwangi want to convince you that there are two parts of that proviso that can occasionally deemed not be terrorists are within the meaning of the definition of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that this should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is. Is not to the burning, destruction, or anything. It's to the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statute interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule the golden rule, when it's used for interpretation, would lead you to arriving at a decision that when such an interpretation would lead to unreasonable or nonsensical results to which the DPP is inviting you to. I rest my case.
On my promise,
Yes, Your Honor. See for the strong words by counsel, especially Mukunji here about nonsensical stuff. I won't respond to that because I know that the decision to charge is a very solemn decision. And we have taken the decision bearing in mind the response, and especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And just to, before I sit down, I just wish to say that there is a lot of misunderstanding on the import of the exemption.
Coming from?
Just give him an opportunity to respond to any.
I don't think he has audience, Your Honor, with due respect, and we wish to object to that,
Yes,
because we are now reopening the case. Fortunately, that is the rule, and the court must be bound by those rules. We can't make our own rules.
I understand.
Yes.
Yes, I also
as much.
I
And so, only to limit. And when Mr. Mashira rose on his feet, I said to him, reserve anything that you want to say, and I'm not opening up for the prosecution to make any new submission.
No, yes.
And to leave it there.
You know, I am well guided, but I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that will make a ruling on that.
Your Honor, with tremendous respect, the Law Society is here and we represent Mr. Mukunji. We are asking.
Yes, Your Honor. Yes, and thank you.
Not to reopen any new issues.
Yes, thank you. Thank you to the Deputy President of the LSK.
But Your Honor, until when shall we be integrated by the
As long as you remain
Just to save time, the Deputy President LSK went into the realm of new matters. And therefore, once you go to the realm of new matters, it gives a remit to the DPP to address. But I'm not going to address anyway.
Yes.
Just a sentiment. The DPP, and that is what I was saying before I was told to say. Each other with a lot of professional courtesy. This is not between us, it's not between you. The matter only affects these people that are before this court.
So then I do not think that needs any response.
It doesn't need. That should not be allowed. Or only that, Your Honor. No.
In regard to Ms. Tiga
Yes.
and Peter, of course we will be making the same application.
Yes.
If we can simply proceed with those two.
Indeed, I think given for the time.
And in those two, we will mostly be adopted.
Good. So, the state is in agreement.
We are in agreement.
Call out the next file. So for the accused persons in E068 of 2025, you may be seated. Wale ambao wameitwa kwa kesi ya Daniel MATIANG'I unaweza kutafuta mahali hapo katika. So call the next file. those that are remaining, please call it out.
Criminal number 70, 2025, State versus Peter Kinyanjui, alias Sarah Wanjiko.
Yes.
They should be here.
Peter and Sarah.
Please call them. Please call them. Please let me have the files.
Questions?
This is a fresh matter.
These are fresh matter.
And we taking quorum. Is the new councillor is coming into Mr. Nguinga.
Yes.
Yes. DCP, Democratic. A party in coalition with several others, including those represented by Council. Honorable Gachagua, Gabi. That you are seeing state high-handedness. Whenever they hear the name Brigadier Gachagua. I'm going to invite Council Kibe, MATIANG'I, to highlight the circumstances. Is haunted and charged with terrorism. And I therefore want to invite Wakili, because these two were even admitted. As if they were Al-Qaeda criminals. Or Al-Shabaab. And wanted to peace. By my learned colleagues.
So what we shall be submitting on is try to make some Your Honor, apart from the and the taking off from the charges that are before this court. In Kiambu, miscellaneous criminal application number the Honorable Mr. Honorable Gedi to the Chief Magistrate. Of Kiambu.